Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So the first one I want to talk about, Phil, we have really talked quite extensively on our program about DE&I, diversity, equity, and inclusion. And I have been saying for several years now that employers that want to go down this road need to do it very carefully, because there are potential legal pitfalls in implementing diversity, equity, and inclusion efforts. And a report out from a law firm called Duane Morris, which is a well-respected large law firm in the United States. They issued a report saying that the DE&I efforts are likely to spur a rise in class actions in 2025. And so I just wanted to highlight that and bring that to people's attention. DE&I challenges, as you know from the news, are on an upward trajectory. The potential increase in class actions that implicate corporate DE&I programs and other environmental, social, and governance initiatives is definitely an emerging trend. And one of the quotes that comes out of this report is that it was this one: without a blink of an eye, courts were applying the Supreme Court's decision, and that decision is the one on admissions cases at the universities involving Harvard. But without a blink of an eye, courts were applying that Supreme Court decision, and plaintiffs' class action lawyers were using it to send out attorney demand letters or to file lawsuits on behalf of clients, saying that to the extent an organization or company put diversity over merit, they were liable under that Supreme Court case.
Oh, wow.
And so, yeah, so
that
we've
could be
seen
huge. Yeah.
Well, it could be. And we've seen a range of cases brought against businesses, both on an individual basis and a class-wide basis, to challenge those sort of policy statements. Now, it's going to get even more interesting because the Supreme Court accepted a case recently called Ames, A-M-E-S, versus Ohio Department of Youth Services.
Not Ames Employers Association.
No.
Let's be very clear. Okay.
That's why I spelled it.
Yeah.
That's why I spelled it Ames versus Ohio Department of Youth Services. The Supreme Court agreed in October to consider whether to revive a heterosexual employee suit alleging she was passed over for promotion and later demoted because of the department's bias in favor of LGBTQ employees. So again, I go back to what the employment laws say. They say we need to make employment-related decisions without regard to the protected classes. We can't consider the
That
protected
is the
classes.
key. Yes.
Yes.
Yeah.
And so
I know,
again,
we do, just on that, I know your firm does, and our association does a lot of work in the space of affirmative action planning. And, it's interesting. Every now and then a client really does a great job, and they say, hey, help us understand our affirmative action plan. Not just do it, but help us understand what we should, in your plan, you're committing to what you should do and what you're going to, but help us understand how to do that. How do we do that in the most unbiased way, but still meet the expectations of what we're trying to achieve without being biased in that way? And that is, it's really important to understand that and not hire for the purposes of your affirmative action plan.
That's right. It as I have said, it is a very fine line, and you need to make sure that while you're encouraging opportunity, you can't go so far as to start making decisions based on protected classes.
Yeah, absolutely. Okay, what else you got there?
This one was really interesting to me. And a National Labor Relations Board judge, so an NLRB judge, gave approval to Apple's firing of a mass emailing engineer. And this was really interesting to me because this employee, she was an engineer working for Apple, and she was sending out mass emails and Slack messages in 2022 following disagreements with colleagues over a project she was working on. Apple eventually disciplined her and terminated her because the emails were disruptive and disrespectful. And once they fired her, she brought an NLRB charge claiming that Apple fired her because she was engaged in protected concerted activity. The board, kind of surprisingly to me, because I think that this current board has really been aggressive on these on what they consider to be protected concerted activity. Ultimately, this NLRB judge concluded that while she was complaining about workplace issues, she was complaining about workplace issues that were particular to her, and she was not engaged in protected concerted activity. She wasn't acting with at least one other employee to complain about terms and conditions of employment. So again, I think this is one of those that it serves as an illustration that
there's a fine line here, isn't there? And
well,
what is actually protected concerted, or what's one person with a microphone and or an email system speaking out or distributing a message isn't necessarily concerted.
That's right.
Now, if I elect into a group, or I'm starting to correspond with the group, or we're starting to plan and come together as a group, I think that's where the line would start to change. I don't know how you would describe that, but just blasting my unhappiness
exactly
is not protected.
It's not concerted activity.
Not concerted, excuse me.
And I would like to give a quick shout out to Jen Betts, who's been on our program before. She was one of the attorneys that handled that case. So just a quick shout out to her.
Good job, Jen. Yeah.
We'll have Jen back on.
That's one for Ogletree.
Exactly. Another one for you, Phil, and this goes back to the origins of our This Week at Work show, when we started way back during COVID. And one of the things that we talked about was, remember when we were screening employees for whether they had COVID or not? We were taking.
They were lining up at the door.
Yeah.
Let me guess, you're going to say something about, do I have to pay them or not? And I remember our conversations. Is that where you're going?
That is exactly where I'm going with this. O'Reilly Automotive Enterprises.
O'Reilly? That O'Reilly?
That is. You gave a good plug, Phil. So O'Reilly had been accused out in California, of course, of failing to compensate employees for the time they spent undergoing COVID-19 screenings before their shifts. So this is interesting. It is California specific because the case was brought under California's PAGA, P-A-G-A law. That's their Private Attorneys General Act law. The plaintiffs had originally filed this a lawsuit under the Fair Labor Standards Act. That case was dismissed, but when they refiled the suit under PAGA, it stuck, and O'Reilly settled this case for $4.1 million. And so,
holy cow!
Yeah, a lot of money involved there, including $1.3 million in attorney's fees. But just to point out again that when employees, if they're undergoing some sort of process on the way into work, you think of what we call the donning and doffing cases, particularly with respect to safety equipment and those types of things. Just a caution to employers to remember that time is usually compensable. Yeah,
that's and I know we talked about that, and we suggested, yes, that should be at the time. It's too bad O'Reilly wasn't a member of ours, and in that circle of communication, we would have saved them a little bit of money there.
We would have hoped to do so. Yes.
Yeah, absolutely. Yeah. Anything else there, Burt?
Yeah, there was one other that I thought was kind of interesting. A black worker, a former employee of a poultry factory, is arguing that the secret recordings he made during his employment should be admitted into evidence. The employer is arguing that the recordings are hearsay, and the employee is arguing, well, they're not hearsay. I made the recordings and I can authenticate them. And so the judge is considering whether to admit those recordings or not. And I really only raise the case just from the standpoint.
What state is that in? Does it say?
Yeah, this one is in North Carolina, and North Carolina is a one-party consent state. And so the individual said, I made the recordings. I can authenticate the recordings. They are not there for hearsay. And judge, you should deny the employer's motion to exclude those recordings. And again, I just bring up the case to remind employers that with cell phones these days and other spy-like devices, recording devices, including what can be in an employee's eyeglasses or whatever. Just keep in mind that in your dealings with the employees, oftentimes I will tell employers, just assume you're being recorded and act accordingly on the recording or during the conversation. And also in today's remote work environment with things being done over Zoom, it's very easy for an employee to simply have their cell phone sitting out recording the Zoom meeting, etc. Just presume that you're being recorded, and don't say anything to the employee that you would be embarrassed to have a jury hear months or years down the road.
The other thing, Burt, and that is good advice, and it'll be interesting to see how that one unfolds. I would have to imagine it may be admissible just because it is a one-party state. But the other thing that I would also offer caution on is today, imagine this scenario. You're in a serious conversation with an employee, and you have a representation of management sitting in the room with a representation of HR in the room and an employee. And for some reason, the employee leaves the room to use the restroom or get a glass of water, whatever it might be, but they leave their phone in the room. And in addition to the recording, if they have earbuds, they could put those in. That phone today transfers that very clearly to those earpods, as long as they're within Bluetooth connectivity range, and that person can hear everything. So, sometimes the conversation outside the main room isn't for everyone, and it may even not be recorded, but it could be listened to. And I just offer that awareness to people because, I'm assuming you're not trying to do all the wrong things, but sometimes there is a conversation for management that isn't had with employees. Yes. And it could be misinterpreted, and it could create a big problem as well.
Yep. Just, again, without going overboard and becoming paranoid, just make sure you have your guard up.
Absolutely. No, those are some good ones there, Burt.
Yeah.
Thanks for being an on-demand viewer of This Week at Work. Don't forget, you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning, when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.